Now, House of Representatives is pushing for reforms to ensure faster and more accessible justice delivery in the Federal Capital Territory. Chairman, House Committee on FCT Judiciary, Honorable Adamu Gamawa, stated this during a public hearing on two bills in Abuja, one seeking to increase number of judges in the FCT and another to establish lower courts with civil and criminal jurisdiction. Honorable Gamawa emphasized commitment of the House to timely justice and reducing burden on existing judges, emphasizing the reforms align with Speaker Tajudeen's vision of making justice affordable and accessible to all residents. Speaker Abbas, represented by Deputy Minority Leader Honorable Aliyu Madaki, described the bills as urgent steps toward necessary judicial reforms, while President of the Nigerian Bar Association, Afam Osigwe, SAN, backed the proposals but called for removal of Section 16 of the Principal Act, citing need to review aspects of customary law.
Well, there are two bills actually. One is to increase the number of judges in the FCT to at least not less than 100. We all know that the federal capital is expanding every day. People are coming in. Wherever you have so many people, you expect to have some disputes. So the burden of the cases on the present number of judges is very, very cumbersome. So we want to pass this legislation, which is also a constitutional amendment, so that we have more number of judges in the FCT to have less cumbersome cases on the judges this is presently. Then the second one is to establish lower courts, magistrate courts at the lower level. There's no law actually backing them. The law establishing them is an old one since 1960s. So there are so many conflicts of jurisdiction within the law presently. So we want to see where we can seamlessly apply these laws to our people.
This public hearing is a direct exercise of that constitutional mandate. It affirms our commitment to check and balances, good governance, and the rule of law. As we deliberate today, we must be guided by the larger goal of enhancing justice delivery and strengthening institutional frameworks. The importance of these bills lies not only in their legal content, but also in their potential to reshape how justice is assessed and administered within the FCT.
If you also take the cognizance of the fact that Section 15, I think, has earlier made provision that it can apply principles of common law and equity, and then also now saying it should also apply principles of common law, that may create a problem. And to avoid conflict of jurisdiction, as that would also implicitly suggest that since it can apply principles of common law, then it can adjudicate on common law issues. As an earlier provision has said it cannot adjudicate on common law issues, let us expunge that section that gives it power to apply customary laws.